sellers. We're seeing telephone companies or wireless providers using it to go after people who flash and resell cell phones. And is this really what we want to do? Maybe not. So on the one hand, you're getting a lot more questioning from Congress about the ongoing legitimacy of the statute. On the other hand, you're getting a Copyright Office issuing more exemptions to the statute than ever before. Well, not more than ever before, but kind of liberalizing the circumstances under which they'll issue one of these exemptions. So I just got one in the last round of exemptions for the cell phone unlocking, and there were a bunch of others too. Film professors got one to be able to show snippets of their movies to their classes. There's some exceptions for archaic software that's on no longer functioning dongles. There's a lot of interesting exceptions if you're interested in taking a look at that. But this statute, which is been a real problem for researchers and a real source of fear, I think, for some overseas researchers, may be losing some of its support and power. Okay, trade secrets. This is another kind of intellectual property, and a trade secret is basically something that is valuable by nature of it being secret, and that the companies tried to keep secret. Well, in the Michael Lind case, what was the secret, right? So they charged him with trade secret violation. What's the secret? He had access. He didn't have access to the source code. He had the binary code. They sell the binary code. You can just get that. So if you decompile publicly available code, are you getting at any kind of secret? Well, no, because it's not secret because they're selling it, and you're not misappropriating it because you're not using any kind of improper means to get at it. Reverse engineering or independent derivation is not going to be improper means. So, what's the secret? And the one question is the product flaw itself a secret? And I have had, in people that I've represented, I've had many attorneys for vendors that have flawed products call me up and say, the fact that it works in this particular way and that's not very secure, that's our secret. So don't disclose that. Which I think is sort of, shocking. In 2003, the company Blackboard claimed trade secret violation and got a temporary restraining order and prevented some researchers from disclosing security flaws in that company's, I guess there were door locks or door access devices at Interzone 2 in Atlanta. So, you can imagine if we had this same rule with cars, it's like, okay, when you rear end the Gremlin, it blows up, but we don't want you to know that because it's valuable information because it's secret. If people knew it, the value of our product would drop. So, let's not do that. And, one of the problems is that, other than kind of you have overzealous attorneys, but you also have judges who are not particularly familiar with software and sort of weird, and so, you worry that somebody might actually believe this as an argument. Okay. Any question about that? Yeah. Yes. Yeah, so his question is, okay, there's kind of a big difference between can you play your PlayStation game on your computer and your car's going to blow up? So do courts recognize the nature of this distinction? And I think the answer has been both sort of inherently or sort of subtly, yeah, but actually no. So let me sort of, kind of illustrate. I think that in any case that you try or you go forward with, especially when you're trying to change the law or the laws a particular way, you want a set of facts where the court's going to be like, if I you know, if I do this, which is the kind of what the law tells me to do, or is sort of the easy path or something like that, all these other horrible things are going to follow. And I don't want to be the guy who says that, you know, sorry, your gremlin blew up, but I thought it was a trade secret, you know, because the judges are people too, and, you know, they got to go home and sleep at night as well. So to some extent, some of this is taken into account. That's one of the reasons why, you know, it's very hard to win. I think for now we've had some trouble winning civil rights cases about the right to reverse engineer and the right to fair use, and making fair use so robust and important when we keep raising it in circumstances that have to do with copying DVDs and video games, because while, you know, normal people care a lot about their media and their music and their entertainment, courts are like, you know, what the hell, who cares, right? Whereas with a car, you would really care. And there's a paper that one of our fellows from last year wrote, David Levine, about the problem of trade secret law protecting things or security vulnerabilities in some of our kind of more critical infrastructures. That's probably not the right word, but things that are important to our health, like cars, or like the Cisco routers, which are not just computers, but run the backbone of the internet. So if you have a vulnerability that allows you to execute arbitrary code on those routers, that's pretty serious stuff for the internet. Maybe people should know. Or with voting machines. And that's one of the areas where we're really seeing this trade secret versus public right, you know, battle going on. What could be more important? You know, these voting machines are like the mechanics of democracy, right? And yet they're out there with this proprietary code that the companies don't want you to see because it's a trade secret. So how do we know whether it works? And, you know, if we enforce trade secrets versus kind of the public's access or the public's need to know, when we have these like very important matters, then, you know, what are we protecting? Now, the thing about trade secret law is that it differs from copyright law. Now, copyright law is always at least given lip service to trying to have this balance. You've got the incentives, and then you've got fair use and the public right of access, and these are supposed to be kind of in balance. We recognize that there's some public right. With trade secret law, we don't really have that kind of thing. You know, a lot of the stuff that's accommodations for the public interest in copyright law, we don't have in trade secret. Trade secret, it's like you tried to keep it secret, it's valuable to you, it's secret, there's no time limitation, right? The Coke formula is still a trade secret, and you know, it just sort of goes on like there. So where do we have any room in the doctrine for this very important issue of maybe keeping this secret is harmful to the public interest, right? And so that hasn't actually been fully developed or fleshed out yet, and it's something that we still have to fight over. So it's still a unanswered issue. But if you're interested in that paper, it's on SSRN, and the author is David Levine, and he kind of goes through a couple of these examples talking about the way trade secret law might evolve and the limitations of how it is currently, specifically for these important matters of public interest. Okay, well, I haven't talked about HID at all, but let's sort of, so to crystallize, you know, one of the main questions that I have is the question of the impact of copyright law and or rather contract law, and what a EULA or a terms of service or a non-disclosure agreement can stop you from doing that you ordinarily would be allowed to do, okay? And there's a big difference in some of these things, because one of the things we say in the law is like, you know, if you have a right but there's no remedy, what's the good of having the right? You know, if you say, well, yeah, you're entitled to fair use, but if somebody denies you it, well, you're not allowed to do anything. It's like, well, you know, that isn't so much of a right. What the ramifications are matter. So if I have a EULA or a terms of service, a contract that says you're not allowed to do something, and as a result, it takes away my right to fair use, and now I'm a copyright infringer. That can get you into statutory damages, which is like set forth damages in the statute regardless of how much harm you actually did. Some kinds of copyright infringement are criminal, and, you know, maybe you could get in trouble for something like that. That's kind of serious. Whereas if you say, well, you know, I had a contract, and this contract is something that said you weren't going to reverse engineer, but you did. But I'm not going to say that you violated copyright law as a result, because copyright law says you can reverse engineer. We're not going to look at the contract as impacting that decision. The contract's just a contract, and you breached a contract. Well, breaching a contract is, you know, for business people out there know, it's something that happens. And there's no kind of moral opprobrium that goes along with breaching a contract. A contract helps kind of level and mitigate risk. And if I feel like by breaching the contract, I'm going to go do better somewhere else. All you're entitled to is what your expectation, usually financial expectation was. I pay you off and I go make my deal with the other guy. And if that's economically efficient for me, then that's what I'm allowed to do. And I'm not going to go to jail and I'm not going to get punitive damages. And only in very rare cases am I going to be forced to actually go through with my end of the contract. Mostly just paying you off is fine. It's economically rational, it's okay. So there's a really big difference. One question when you say, well, somebody did something wrong, one really important question is, well, what does that mean, right? How severe are the penalties? What legal regime's triggered by the fact that you did something wrong? And so that's my questions about the contracts. I'm not saying contracts are bad, but I'm saying if contract law takes away rights we have under reverse engineering or fair use law, or rights we have, under other sorts of statutory schemes, and then throws you into like a criminal or a severely penalized economic context, that kind of extra sucks. So here's some cases on EULAs. These are a little bit old. I cite 2 new ones that are very interesting in my Wired column that was up on Wednesday. Okay, so patent infringement, and we'll talk a little bit about HID, and then I'm going to stop in like 5 minutes so we can just do some questions. So here HID claimed that there was patent infringement, or at least suggested that there was patent infringement, and for patent, you have to violate it, you have to make, use, sell, or offer for sale an invention that's described in the patent's claims and without the patent owner's authorization. It's different from contract in a lot of ways. 1, it's shorter. 2, it does protect ideas and functionality. And 3, it requires you to disclose these when you register for it for the patent office, so that after the term of the patent protection is over, the public gets to take advantage of your brilliance in having created this great new machine or device or innovation. So, was this a valid threat? Well, it's like, well, if you have a reader or a RFID reader, and my reader or my spoofer operates in the same exact way, then in theory it makes some kind of sense. So it's like, ooh, that's kind of scary. Although one of the nice things about patent infringement is that you don't get statutory damages, you only get actual damages. So you have to see like what the harm really is, and if there's no real economic harm, i.e. I'm not piggybacking on your genius in order so that I can make money, then you're not going to really get any kind of real damages there, and so the downside's pretty low, which, as I said before, is a great question to ask, because it's like, oh yeah, you violated the law, but guess what? You get the slap on the wrist, versus you violated the law and you're going to get statutory damages, and it's going to be trebled because it was willful, and now you're bankrupt and you're totally unhappy. Okay. So this issue of patent law raises some other really, and this sort of restriction raises some other really interesting questions on the other side, right? These copyright owners or big companies aren't the only people who are benefiting in a potentially scary way. So this was brought to my attention a couple of months ago, this intellectual weapons program or effort company. I don't know exactly what it was. The website doesn't exist anymore, but basically, this was a group that wanted to do security research, find vulnerabilities, patent the fixes for these vulnerabilities, and then make money by selling the fixes to their customers and not letting either the vendors or non-customers fix vulnerabilities, patch vulnerabilities, because that would be infringing their patents. Okay, so basically, it's like, let's flip it on the head, right? Here you have vendors that are the bad guys, right? Who are like, oh, you have to pay us, or you can't tell anybody our stuff is insecure. And then on the other side, there's still more bad guys. It's like, oh, well, 2 can play at that game. Guess what? You're going to say we can't show how your we researchers can't show how your RFID reader is insecure. Well, guess what? We're going to find out how to secure it, and you're not going to be allowed to secure it unless you pay.